Welcome everyone. I would like to start by acknowledging the country on which we are holding this presentation today. We are on the land of the Wurundjeri people. Melbourne Uni takes our job very seriously in this regard. It's a big focus for the university and the law school in particular. So I really like to pay my respects to elders past and present. My name is Tess Hardy. I'm the Director of the Centre for Employment and Labour Relations Law. I'm really pleased to be holding this seminar this evening and really fantastic attendance, which is excellent to see. I would like to thank the sponsoring firms. We are a centre, a special centre within the law school. We receive funding from various firms and organisations, and that allows us to hold these types of events and activities. So without their support, we would be unable to do so. So thank you to those organisations. And I'd also like to thank and welcome and introduce our speakers for this evening. So we are really excited to have Professor Virginia Mendavalu over from the UK. She is a Professor of Labour Law and has written extensively on human rights at work, which is the subject that she is currently teaching in the Masters at the moment. So it's a huge honour to have you in Australia. We're very excited as a centre to be hosting Virginia, and I really appreciate you making the time to give this seminar when she's jet-lagged and has been teaching all day. So it's especially impressive, so thank you, Virginia. And I'd also like to welcome and introduce Jacqueline Meredith, who is a former PhD student, recently graduated from Melbourne Law School and currently works at Swinburne University of Technology. And Jacqueline did her research, her PhD research on the work-non-work divide in labour law, which I thought was particularly fitting for the topic which we are going to discuss tonight, which is discipline and dismissal for social media activity. So over to Virginia. Thank you.
Okay, thanks very much for the invitation to Tess, Sean and all the other labour law colleagues at the University of Melbourne. I'm really delighted to be here. It's a real honour for me to be here. I'm loving teaching the students in the master's course. And it's great to also have the opportunity to talk to you tonight. Is it morning or evening? I'm not certain. But to talk to you about this topic that I find extremely interesting and have such a great commentator like Jackie, who wrote a great PhD on this issue. This is about discipline and dismissal for social media activity. So discipline and dismissal for social media activity. I'm sure that you all have probably read in the news occasionally that there are people who lose their jobs because of what they do on social media. It is very common nowadays. This is something that we did not have about, say, 10 years ago, and certainly not 15 years ago. But nowadays, if you do a bit of research on employment courts, employment tribunals, databases, you'll find dozens of cases. This is how it happened to me. I was getting ready to go to a conference on technology and labor law, something like that, and I decided to focus on this topic, discipline and dismissal for social media activity. So the question that I have for today is this: is it fair for people to lose their jobs because of what they do on social media? And are there ever any limits to the employer's managerial prerogative, to the employer's prerogative to discipline or dismiss people for what they post on social media? So, you may have seen a few years ago, there was some examples. There was this woman who saw the motorcade of President Trump when he was president in his first term, and as he was passing by, she did a vulgar gesture, understandably. But someone took a photo and it was posted on social media. It was posted on she posted it on her Facebook page or shared it on her Facebook page. Soon after that, she was dismissed. She lost her job for that reason. It was outside work. It didn't have anything to do with her work. Other examples, a woman working in a care home had organized an evening for the people that were the residents of the care home, and she recorded the evening where there was singing and dancing, and she posted it on her Facebook page in the UK. That's an example from the UK. And she lost her job for posting some images where you could identify residents of the care home without having got permission. People may post silly things on social media and they can very easily lose their jobs. What has changed nowadays with social media? What has changed in relation to how things were in the past? I think the change is very significant, and the issue that has changed is that nowadays employees, all of us, we can post things very quickly and spontaneously on social media, very spontaneous things about things that happen to us every day, or to commenting on politics, engaging in debates, sometimes engaging in very passionate debates with people. And the major change, people were always discussing and debating things, but the major change is that with social media, what we post on social media is there permanently. We may think that, we can delete a post if we regret it, or we may think that our privacy settings are such that not many people can see it, but this is never the case. People can always access what we post on social media, and even if you delete it, you know that it can always be accessed, either because people took a screenshot or because there is an archive with our social media posts. So in the past, people would have discussions, debates with colleagues by the water cooler, in the cafe, in the pub after work, or elsewhere. Even if they had a heated debate, that would be it. It would just be between 2 people or 4 people or 5 people, whoever was in the pub or by the water cooler. Nowadays, when we have debates, when we express views, when we share our private life on social media, it leaves a permanent mark and it can never really be deleted. So this is a major change. There are a lot of social media and employment law cases. These are just 2 examples from the UK, not any major developments, employment in terms of precedent, employment tribunal cases. Just as examples, for instance, in the Laws case, Mr. Laws was employed by a games retailer, and on his Twitter page, where he did not identify his employer, he posted remarks on things that he didn't like, very, very rude remarks about Newcastle fans in football, I think, about some NHS workers, National Health Service workers, and some remarks on people with disabilities, etc. They managed to identify him because he followed his employer on social media. They identified him, they didn't like his comments, they dismissed him. Gibbons is perhaps more interesting. Ms. Gibbons worked for the British Council as a head of global estates. And one day she was on her Facebook page and she saw a post with a photograph of Prince George that had been posted on the Facebook page by a rock band, the Dub Pistols. I don't know. So they posted this photo of Prince George when he was 2 years old, and it was accompanied by a very rude remark about Prince George. And she had not posted the rude remark, but she posted comments agreeing with the criticism of the royal family, of white privilege, and other such issues. It was seen by someone who was her friend on social media, her Facebook friend. It was reported in the tabloid press. It was front page in the tabloid press that misrepresented her remarks. This is, how they do it. This is where taxpayers' money goes. We pay these people to work for the British Council, and they say rude things about Prince George. She ended up losing her job from the British Council because of the damage on the reputation of the British Council through the tabloid press that had misrepresented what had happened. So both these cases went to employment tribunals in the UK. The question that I'm particularly interested in is whether the protection of workers' rights, human rights, can have any impact in these cases, and with a particular focus on UK law and European human rights law, and Jackie will discuss more the Australian example. So first of all, just to say that in the UK we have the Employment Rights Act that protects people from unfair dismissal. There is Section 98 of the Employment Rights Act that says that there has to be fairness in dismissal. There's a test of fairness, and then we have the Human Rights Act that protects a list of rights, including the right to private life, freedom of expression, the right to life, and all these traditional human rights. And the Human Rights Act has some horizontal effect. This means that when courts interpret the Employment Rights Act and the protection from unfair dismissal, they have to interpret it in light of the Human Rights Act. So the question is, when someone is dismissed and they invoke their protection from unfair dismissal under the Employment Rights Act, is their claim strengthened by using human rights law? Why am I asking this question? Because the test of fairness in dismissal in English law is a very weak test, giving great discretion to employers. Tribunals and courts say that there is a wide range of reasonable responses, very broad discretion to the employers. While in human rights law, as I will explain a bit later, we have a stronger test, a test of proportionality, when a dismissal may violate human rights, workers' rights. And I think this is significant. This could be significant in the cases that we're talking about today, the disciplinary action and dismissal for social media activity. So there are two rights in the European Convention on Human Rights Act, that are relevant to dismissals for social media activity. First, there is the right to private life. We have Article 8 of the European Convention on Human Rights, which is incorporated in the Human Rights Act, that says that everyone has the right to private life. The problem, however, is, and this is the next question, are social media posts private? Unfortunately, UK courts, when they look at activities in public space, on the internet or in other public space, including social media, they tend to say that these dismissals cannot be protected at all under the right to private life because they take place in public space. I have a couple of examples of cases that have very interesting facts. I will not go into this in detail. The last one is about the internet. Lawrence and Secretary of State for Justice that I found. Yes, this is the most recent and the most interesting in this respect. Ms. Lawrence worked for the Secretary of State for Justice, and in her free time outside work, she published erotic photos and videos on the internet, on YouTube and on the internet. I don't know where exactly on the internet, not on social media, but yes, on YouTube. And this was found out by her employer, and she was dismissed. She claimed that this was her private life. This had nothing to do with work. But as they had found this case, the photos, this content online, they dismissed her. She lost, like in the previous two cases that are about different issues, but again about activities in public space. The tribunal in her case, when she challenged the dismissal, the tribunal said that this is not an issue of private life at all. The right to private life is not even relevant at all because these photos that she posted and videos, they were online. On the internet, in public space, this is not covered by the right to private life. This is incompatible with the case law of the European Convention on Human Rights, von Hanover and Pay versus UK, because the European Court of Human Rights, when it examines the right to private life, it says that it can, in principle, also cover activities that take place in public space. So employment tribunals in the UK, unfortunately, get this wrong by saying that social media posts can never be covered by the right to private life, because the European Court of Human Rights has said in several cases that activities in public space can, in principle, be covered by the right to private life. This should be obvious. But generally speaking, we know that the right to private life in employment has a very broad scope. In this very important judgment called Barbulescu versus Romania of 2017, very important judgment on workplace privacy of the European Court of Human Rights, the Grand Chamber of the European Court of Human Rights said that yes, there can be restrictions to the right to private life, but an employer's instructions cannot reduce private social life in the workplace to zero. In this second very important case of the European Court of Human Rights on dismissals and dismissal and human rights, dismissal and private life, the Dismissal versus Ukraine, the European Court of Human Rights again said that life away from work is in principle covered by the right to private life in the European Convention on Human Rights. So the right to private life has a broad scope, but in domestic courts, unfortunately, in the UK, in cases of dismissal for social media activity, they just reject it as a right. That is, they say it's not relevant because of the public space. However, we also have the right to freedom of expression, Article 10 of the European Convention on Human Rights, that says that everyone has the right to free speech, which includes the right to share opinions and express views, etc. In the case law of the European Court of Human Rights, we find that political speech particularly, like the speech of Ms. Gibbons in the first case that I mentioned, political speech enjoys particularly strong protection, while trivial speech, what we find on social media, as you know, it's usually really trivial speech. People share a lot of things that no one is interested about, and start discussions, debates about these kind of things. In UK courts, we see that because social media speech is mainly trivial speech, they don't find that it enjoys any strong protection. However, what we really know very clearly from the case law of the European Court of Human Rights is that offensive speech is covered by the right to freedom of expression. In a long line of cases starting from Handicide in 1976, the European Court of Human Rights has said and confirmed again and again that even speech that offends, shocks, or disturbs is covered by the right to freedom of expression. So then, when we say that social media dismissals may be covered by some of these rights, we don't mean immediately, we don't mean that this is the end of the discussion. To the contrary, if we say that one of these rights is that there is an interference with these rights, then there is a test of proportionality. So then the European Court of Human Rights and domestic courts in the UK examine whether dismissal or other disciplinary action meets this test of proportionality, whether the employer had a legitimate aim and whether the disciplinary action or the dismissal was strictly necessary restriction of the rights. So both of these rights have a test of proportionality. We know from case law that speech that can be offensive can be protected, but we know also from other cases, not the case I mentioned here, that racist, for instance, speech is not protected, that if someone expresses racist remarks on social media, it may be a legitimate ground to lose their job. This case that I mentioned here is a very new case. I haven't quite got exactly my head around it. Higgs of the Court of Appeal in the UK, a very important case. It's a case it's not a human rights case, it's a case where they invoked equality law, UK equality law, but the Court of Appeal discussed extensively the case law of the European Court of Human Rights on freedom of expression. Ms. Higgs expressed views on Facebook that were viewed as objectionable, which some viewed as offensive about sex education at schools, sexual orientation and other sex education at schools. and she lost her job. And here, the Court of Appeal, the UK Court of Appeal, found that her dismissal was unlawful, contrary to the UK Equality Act. And to interpret the UK Equality Act, it relied very extensively to the case law of the European Court of Human Rights that says that how strongly protected freedom of expression is, and the importance of protecting even speech that some may find offensive. So that's a very significant development where we saw that the Court of Appeal gave strong protection to someone who lost her job because of offensive views that she expressed. And the court really applied the test of proportionality for the first time, more or less. So very important development. So I have 2 more slides. I don't have 17 slides. These are combined, our slides. So I have 2 more slides, I think. What are the limits to what we post? First of all, there is this issue of the employer's reputation. What is a legitimate reason for people to lose their job, for social media posts? Harm to business reputation may justify dismissal. If I start posting on social media that UCL is, negative things about, I don't even want to joke about this, it's been recorded. It's always tricky. You don't want to lose your job for talking about this issue. If you damage explicitly, deliberately on social media or anywhere, or generally in public, your employer's reputation, then this can justify dismissal. However, we have to be very careful about this. We have seen in many cases, we have seen in many cases that sometimes it is prejudice of society, majoritarian preferences that lead to mobs responding to what someone may have posted on social media. We saw earlier in the first case I mentioned, the Gibbons case of the employment tribunal in the UK. She lost her job. There was a damage on the reputation of the employer, but the damage on the reputation of the employer was because the tabloid press misrepresented what had happened. We have to be very careful about identifying real damage on the reputation of the employer. Very often, people lose their jobs because the employer wants to dismiss them for some other reason. That is the reality, and we have seen it in several cases. They want to dismiss someone because they don't like them, him, her, anyone they don't like. And they go through their social media posts and they find something that doesn't sound great. And they say, oh, that may potentially damage our reputation, potential damage on reputation. There are cases on this where sometimes courts have managed to see through the decision of the employer and say, look, it is not really that you are worried about the damage to your reputation. You were not very happy with this person's performance or with this person's political views. That's why you dismissed them. So potential damage to reputation, we have to be very careful about accepting it as a legitimate reason for dismissal. And the Court of Appeal in the UK, in the Higgs case, seems to have taken a very strong position on this issue, that when you talk about damage to reputation as a legitimate reason for dismissal, it has to be real damage with real evidence that there is this damage on the reputation. So finally, the proposal I would put forward, and I've mentioned it at times when I've spoken to employment tribunal judges and on these issues, is this, that courts, when they look at cases like this, they should draw a very sharp and bright line between social media posts that have no link to workplace performance or the nature of someone's job. And these should never be viewed as representing the employer's views. So there should be a clear line in the case law explaining that. The court should draw a clear line. We should have a presumption of privacy or protected speech when people express views on social media that have nothing to do either with their job, they're not during working time. This does not mean that social media, dismissals for what you do on social media are never justified. As I said earlier, sometimes when we have examples of hate speech, there are limits to free speech, and hate speech is one such limit. And we've seen this both in case of the European Court of Human Rights and national courts in the UK. So hate speech, if someone is dismissed because of hate speech that they expressed on social media, that can justify a dismissal. As I said earlier, if someone deliberately damages the employer's reputation, this can possibly justify disciplinary action. Or when if someone harasses people on social media, particularly if you harass colleagues on social media, of course this can justify dismissal. But accepting very liberally, as courts very often do, UK courts very often do, accepting very easily that dismissals for social media activity is acceptable is very problematic, and it can be really oppressive for employees and for all of us who nowadays, many of us, most of us use social media and we post things there without thinking too much. And these dismissals for social media activity may lead to may destroy people's lives because they leave a permanent mark online. So I'll stop here, and Jackie will talk to us about the Australian experience. Thank you.
Thank you, Virginia. I thought I would start by contextualising the Australian approach to dismissal for social media conduct by referring to a few recent high-profile cases that most people probably would have heard about. So perhaps most recently we have the current case of Antoinette Lattouf and her claim against the ABC. So she was dismissed after sharing a Human Rights Watch post about the war in Gaza, which she shared that post and also added a pro-Palestinian caption. Her case is an unlawful termination case under Section 772 of the Fair Work Act. And what the ABC is essentially arguing in this case is that Antoinette disobeyed a managerial directive by failing to comply with the employer's social media policy. By contrast, she is arguing that she was dismissed because of her political opinion or because of her race, and that was an unlawful reason for her termination. So two key things that I wanted to point out about this case. Firstly, when we have a look at the code of conduct that was required in this case, ABC journalists, ABC presenters are singled out as high-risk staff. Because they're high-risk staff, they're required to treat personal content with the same care as if they were actually posting on the ABC platform. So just looking at that, we might think this case already starts to raise some interesting issues in terms of a clash between a journalist's duty to their employer and then also their right to a private life and freedom of expression. Secondly, it appears based on the evidence that she was advised not to post on controversial issues. We might also wonder whether this is somewhat of a vague and imprecise standard, with controversial effectively meaning whatever the employer determines that it should mean based on the facts. Going back a little bit, we of course also had the case of Israel Folau and Rugby Australia, also an unlawful termination case under Section 772. And Israel Folau shared a meme where he made certain claims, including that people such as homosexuals would go to hell. Again, we have a very broad code of conduct in this case. So the code of conduct required Folau to use social media appropriately. And again, we might start to think appropriately seems like a very vague, very broad, very subjective test. In the end, a settlement was reached in the Israel Folau case, also similar in the Scott McIntyre and SBS case, also Section 772, also a settlement was reached, but we see the same type of thing happening. So this was a tweet about Anzac Day and criticising the celebration of Anzac Day. Like I said, a settlement was reached between the parties in that matter. But again, the employer was able to fall back on its broad and very extensive code of conduct. And finally, Comcare and Michaela Banerjee. This was actually a workers' compensation decision involving a public servant whose employment was terminated after she posted 9,000 plus anonymous tweets criticising the government. So it was a workers' compensation case, but what is significant for current purposes is that the High Court's judgment strongly favoured the employer's right to control the worker's expression. We can see that the Australian Public Service Code, under which she was supposed to be acting, required you to uphold the values at all times. So regardless of whether you're at work, regardless of whether you're in the workplace, during working hours. And Justice Edelman in the High Court recognises that this extensive code of conduct can cast a powerful chill over political communication. Okay, so all of those high-profile cases that I just discussed, none of them were actually unfair dismissal cases, even though that's actually how they're reported in the media. Often the media accidentally or mistakenly reports them as unfair dismissal cases. But against that backdrop, what I'm going to do now is actually look at the unfair dismissal framework. This is something that I focus on quite extensively in my PhD research. So when we're thinking about the legal framework for unfair dismissal, the Commonwealth Fair Work Act is actually silent as to the required connection. So we don't have any information about the connection between employment and off-duty conduct. So we might say that's a bit of a gap in the legislation. Instead, we have to look to the tribunal's interpretation of the valid reason criterion, and it is through its interpretation of this valid reason criterion that it articulates what is the connection required between your employment and your off-duty conduct. We have a very significant 1998 decision, the case of Rose and Telstra Corporation. And in that case, Vice President Ross provided us with a taxonomy of the exceptional circumstances, which will provide a valid reason for dismissal. And importantly, in stipulating this taxonomy, the Vice President observed, employers do not have an unfettered right to sit in judgment on the out-of-work behaviour of their employees, and an employee is entitled to a private life. Here is also a good place to point out that in some states and territories, including Victoria, we also have a Charter of Human Rights and Responsibilities, which, among other things, tells us that we have a right not to have our privacy unlawfully or arbitrarily interfered with. And importantly, and tying in with Virginia's presentation, this idea of privacy under Section 13 of that Charter has been interpreted as equivalent to how we should interpret the right to private life under Article 8 of the European Convention. So we have a case here which says, interpreting the Victorian Charter consistently with the European Convention, the Victorian Charter protects people from unjustified interference with their personal and social individuality and their identity. Okay, so as I mentioned before, I had a look at many unfair dismissal decisions as part of my PhD research. And in contrast to Vice President Ross's taxonomy, which we saw before really only allows us to dismiss a worker in certain exceptional circumstances, what I found in my PhD research was that in the 20 or so years since that decision was handed down, there's been quite a departure. Those kind of strict standards about there only being exceptional circumstances, that employees are entitled to a private life, we've seen a move away from that. And so now I'm going to point out a couple of overriding themes that I found in my PhD research. So firstly, in relation to codes of conduct. Codes of conduct have been described by some academics as legal weapons. And having a look at the unfair dismissal decisions, especially in the social media context, there's definitely a deference to the employer's social media codes of conduct. So we've got an example there from the Pearson case, where it was stated that an employer's social media code of conduct is clearly a legitimate exercise in acting to protect the reputation and the security of a business. That said, however, there are definitely different types of employment that we can place along a spectrum. So at one end of the spectrum, we might have public servants. As we saw before with some of those high-profile cases, public servants are often subject to quite extensive codes of conduct, which can pretty easily curtail their rights to a private life and their rights to freedom of expression. At the other end of the spectrum, we might put something like academics, who have a little bit more latitude to express controversial perspectives via social media, because in many university enterprise agreements, there'll be broad intellectual freedom clauses, which in some cases could potentially override or be given more weight than an extensive code of conduct. The second point I wanted to point out after reviewing all the unfair dismissal decisions on social media conduct in particular is that it's very much difficult to try and distill any clear principles as to when dismissal will actually be legitimate. And what we really see in the decisions is quite a lot of inconsistency. So in some decisions, the Fair Work Commission has characterised social media as a private space. In other decisions, they've characterised it as a public space. And in relation to that latter approach, where social media is categorised as a public space, often there's a spatial approach taken by the tribunal, and an assumption that the right to private life is very much forfeited in relation to public conduct, including public conduct on social media. And as Virginia mentioned in relation to this approach, it very much overlooks the workers' autonomy, including their right to exercise lifestyle choices, including in public spaces. Another inconsistency we see in the decisions, sometimes an employee's reasonable expectation of privacy when using social media has been taken into account by the tribunal. So particularly when the employee puts their social media on the highest privacy settings, or maybe it's an older person or somebody not very familiar with social media and they think they're putting it on the highest privacy settings. Sometimes that's been taken into account by the tribunal, and they'll say, well, this person had a reasonable expectation of privacy. However, in just as many other decisions, the tribunal has rejected this reasonable expectations approach. So for instance, in the O'Keefe decision, it was stated that it's actually the nature of the social media comments and their impact on the employer's business that'll be determinative, as opposed to any expectation in relation to privacy. We might also query the appropriateness of the reasonable expectations approach because we know, of course, in many employment relationships, there's going to be an inequality of bargaining power. And what this means is that the employee's expectations, their reasonable expectations, will largely be subject to the whims or the ideological stance of their boss. The third point is that the tribunal rarely actually gives any explicit or thorough consideration to this idea that workers might have a right to private life in relation to their off-duty social media posts. However, what is significant is in the very small number of decisions where you do actually see the tribunal engaging with this idea that there might be a right to private life, where this is taken into consideration and where it's given more than just passing consideration, where it's actually properly considered by the tribunal, that often has a significant impact on the outcome, and often we see in those decisions an outcome that is beneficial for the worker. We also have a small category of cases where, although the right to private life is not explicitly drawn upon or explicitly discussed by the tribunal, when reading the decisions, you can kind of infer its existence in the backdrop. So in particular, I'm thinking of decisions that seem reasonably tolerant of off-duty social media activity. And sometimes we see the tribunal very much downplaying the significance or the impact of the posts. So for instance, they'll describe them as tongue-in-cheek or taking the piss or silly or foolish or satirical. And so although there's no explicit recognition of the right to private life, by downplaying the significance and impact of the posts, you kind of get the sense from some of the judgments that that is what's happening in the backdrop. And the fourth consideration, we know, of course, that employers are subject to obligations under work health and safety legislation, under the common law, and of course we also have the new positive duty to take reasonable and proportionate measures to eliminate sexual harassment. These legal obligations are necessarily going to restrict the scope of a worker's right to private life. So over here on the right, we'll see the Colwell decision. This case involved a worker who shared pornographic videos over social media with their colleagues. And there was a submission in this case that the dismissal involved a transgression by the employer into the employee's non-work life and in relation to matters which it had no proper role in policing. The tribunal did give some consideration to this argument. However, ultimately, the employer's work health and safety obligations and its sexual harassment obligations led the Fair Work Commission to conclude that this was not a case of an employer seeking to intrude too far into the private lives of its workers. So this, of course, is also an issue of coherence in the law. Tribunals are unlikely to prioritise or to give extensive recognition to a worker's right to private life in circumstances where that worker's off-duty social media posts conflict with the employer's legal obligations. But finally, I think we also just need to be aware of the weaponisation or the possible weaponisation of work health and safety law by employers. And sometimes you get a sense in the decisions that employers might be invoking these obligations as a pretext to unjustifiably interfere in the worker's right to a private life. Okay, so some concluding thoughts. Overall, I think the Australian decisions on dismissal for social media conduct reflect a range of different perspectives and are often inconsistent in the approach that is taken. In rare cases, we do have recognition of an employee's right to a private life. However, this is certainly not common practice. Why might we want better recognition of the right to private life in these social media cases? Well, firstly, the need to limit moral tutelage and an employer's ability to exercise their own personal prejudices in relation to off-duty private conduct. Dismissal on the basis of a personal moral stance could potentially subject workers to shame and to embarrassment and be inconsistent with rights to dignity. And finally, we can just think about a key objective or key purpose of unfair dismissal law. Many would argue that underneath unfair dismissal law is a worker protective purpose. And this idea that unfair dismissal law, in having this worker protective purpose, should give appropriate weight to workers' rights to dignity and autonomy in the employment relationship. Thanks.